Here we are today again, Nation of Immigrants. Sorry, I'm getting it set up. So today we're going to be talking about U.S. immigration courts. We're coming back to that topic. Last time we talked about Attorney General certification, and I thought we'd move on the next time we touched base on immigration courts. And then some decisions came out last Friday, Attorney General decisions, and we'll briefly discuss, how that happens again. But then I'll dive into these actual decisions and talk about how this kind of action and activity by the Attorney General in the immigration court system is affecting things, and in particular in these cases. So thanks again for tuning in. Nation of Immigrants, here we go.
You're listening to Nation of Immigrants.
America is a nation of immigrants.
A podcast about U.S. immigration law with your host, Jacob Tingen.
All right, so like I said, we're coming back into U.S. immigration courts. But before we get too far into it, I wanted to share some things. We got these neat stickers. I don't know if you can see that. Nation of Immigrants stickers. I got that one for my computer. We have those for sale on the store as well. And like I said, we've got T-shirts and mugs and those kinds of things. And then also you can always donate to support the podcast. You can navigate to jacobtingen.com and make a donation to support the work that we're doing here, both at the podcast and at the firm, and support paying immigrants' legal bills. It's really important what we're doing and frankly, the discussion and conversation that we're having in our country right now and everything that's happening. So let's jump to the headline. The headline is AG Barr issues 2 decisions limiting ways immigrants can fight deportation. Pretty accurate headline. We talked about this the last time we had an immigration courts episode, and what it said, what we talked about then was that the Attorney General can just kind of jump in and pluck out any case that's currently being heard in the immigration court. He has this certification power that allows him to do that. Sometimes the board, the panel of appellate immigration judges, can send a case over to the Attorney General, but sometimes he can just jump in and pluck them out. And so what's interesting here is the decisions that he chose. These aren't going to be as controversial as other decisions that have been issued. Matter of AB, we mentioned, was very controversial, essentially just overturned years of precedent. Matter of LEA, again, another attempt to essentially overturn well-settled law. Not great looks. But people tend to be less sympathetic towards people with criminal convictions. And these 2 cases have to deal with the impact of a criminal history on an immigrant's removal proceedings. So I am also a little more understanding that we would deport people with criminal histories. And that was Obama's general deportation tactic and strategy, was that, well, if they've got criminal histories, they're a priority for removal. And if they don't, they're not. And I think most people can get behind that. But at the same time, I've also learned that there are unique circumstances in many, many people's lives, many immigrants' lives, that would call for compassion and humanity in the decisions we make, especially if they've lived here for a long time and have U.S. citizen family. So this is an opportunity to talk about a form of relief from deportation called cancellation of removal, because it will be relevant here in the conversation we're about to have. So cancellation of removal is a kind of relief that's available to people who have been physically present in the United States for a period of 10 years or more, continuously, haven't been convicted of certain criminal offenses, and also if they establish that their removal from the country would cause extreme, exceptional hardship to their spouse, parent, or children who are U.S. citizens. Okay, so this is a wonderful humanitarian form of relief. It's a redemptive form of relief. I'm a fan. And then there's this additional requirement in here, which is the crux of the matter in the case that we're looking at today, which is that not only do you have to have been present continuously in the U.S. for 10 years, not only do you have to have a tie to the United States, such as a U.S. citizen spouse or child, but you also have to have been a person of good moral character for that 10-year period. Now, what's interesting is that very frequently we'll have clients get pulled over because broken taillight, and then they get a ticket for driving without a license. And in Virginia, if you get too many of those, they'll give you jail time, and then immigration picks you up. And for those, their criminal history is not an issue, and their good moral character is also not an issue. But then we also have people who get into a little bit more criminal trouble. And so we've got people who have DUIs or multiple DUIs. And so then it is a discretionary form of relief. It's kind of up to the judge at that point. And so you have to start asking questions like, well, does this person actually have good moral character? Yes or no? DUIs, even multiple DUIs, have never been a bar to good moral character, and they are not currently a bar to good moral character. The only thing that the opinion here does in matter of Castillo-Perez is the Attorney General opinion issued by Bill Barr. The only thing that it does is that it says that there's a rebuttable presumption that if you've got multiple DUIs, you don't have good moral character. And so that means that when you present your case in removal proceedings, you would need to rebut that presumption. You would need to present evidence demonstrating that you are a person of good moral character. What I don't like about the opinion is that he says evidence of rehabilitation is not the rebuttal he's looking for, which doesn't make any sense. How else can they rebut if they can't show that they've reformed, gone to courses, have their year chip from Alcoholics Anonymous, and those kinds of things? So I think that that's lame in the opinion, that there's no opportunity for redemption again. And so I'm a big fan of giving people opportunities, and of course, sure, rebuttable presumption. They've got to prove it. They've got to prove that they've changed. And so I think evidence of rehabilitation should absolutely be considered. He doesn't say that it shouldn't be considered, but he says that alone is insufficient. But the thing is judges have to do this balancing test anyway. I feel like this opinion was kind of not needed and kind of pointless, frankly, because as an attorney, as I'm thinking strategy going into a cancellation and removal hearing, whether it's written or not, I'm assuming that if my client has a DUI, I've got to rebut a presumption that he doesn't have good moral character. She doesn't have good moral character. That's how I'd prepare for the case anyway. Even though I know that it's not a bar to good moral character, I still have to address that issue. And I know that the government attorney is going to bring it up as an issue. So the opinion is interesting. And I can see why it was written, but I don't see it as like necessary. And frankly, I don't think it's going to make a lot of waves. Unfortunately, we tend to prejudge people with criminal histories, which is that's unfortunate. But what's interesting here is the things, the reasoning, the rationale that he used, saying that it's a scarce form of relief. Cancellation of removal is a coveted and scarce form of relief. So they only issue 4,000 of these visas each year. And 3,500 of them are issued on January 1, and 500 are reserved for detained cases throughout the year, which creates this backwards scenario where if you're detained while your case is heard, you're going to get your green card faster than somebody who's not detained. And presumably, if you remained detained throughout your proceedings, then your criminal history is worse. So people with worse criminal histories will get their green cards faster. So that's just, I mean, hypothetically, right? So that's just another example of the strangeness that happens and unintended consequences that happens with a lot of these decisions. So, again, I see the rationale. I'm not 100% behind it. I see that it's not going to be controversial because most people say, hey, we don't, especially if you're going to be an immigrant here, don't drink and drive. And that makes sense. I would add, though, that for me, evidence of rehabilitation matters a great deal. People should get second chances. And I think that evidence should be considered. All right. So that's that case. Let's look at the other one, which is matter of Thomas and matter of Thompson. So what William Barr did in this case, in this Attorney General opinion, is he plucked two cases out that had seemingly similar factual circumstances and then said, oh, look, there's confusion. And then, decided, well, we're going to use this test to analyze things and pick the harshest version possible, which Again, not surprising under the current administration. So basically, there's this phenomenon that exists where when people get certain criminal convictions under the Immigration and Nationality Act are viewed more harshly than others. And so the idea is if, for example, you get convicted of something considered an aggravated felony, you're not eligible for relief from removal. You will be deported. There's not much you or any other attorney can do unless you can prove that the government's going to torture you upon your return to your country of origin. Then we're going to deport you. And that's, the consequence of getting an aggravated felony. Okay. Now, that sounds well and good. We don't want aggravated felons running around our country. I get that. It's a whole safety concern. But then when you look at the actual list of things that can be considered aggravated felonies, it becomes a head scratcher. So, one of the things that can be considered an aggravated felony, for example, is the list starts off with rape and murder. I'm like, okay, great. Aggravated felonies. I get it. But then later on down the list, it says things like a theft offense of which the term of imprisonment is more than 1 year. And so, that's shoplifting. And again, not great, but hardly what I would call an aggravated felony. And in most states, it's a misdemeanor charge. And depending on the value of the goods stolen, it's like a minor misdemeanor that could likely be dismissed with community service and those kinds of things. So that's part of my issue with this case is that that's kind of a good place to start. You've got aggravated felonies, and you've got a crime that, frankly, at the state level just isn't a felony, but could be considered one under the Immigration and Nationality Act. And so sometimes what happens is you'll get a client who has a criminal charge and conviction, and then you'll take it to the immigration court. And at that level, it's decided that, oh, well, your client has an aggravated felony. And so you might go back to the state level and say, hey, is this what you really intended? Because this is a low-level crime. I'm sure you didn't expect this person to be deported based on such and such a crime. Can we modify the sentence somehow? So this opinion that Attorney General Barr wrote looks at, the state of things among the BIA, and he talks about these two different tests, that if the order is modified, that the BIA doesn't consider a modified order if the state court, took a second look at the sentencing and modified it, versus an order that the state court just clarifies. And there is a difference there, right? Like if I'm just modifying the order, that I'm changing it for the immigration benefit. Okay, fine. Or for the resulting lack of an immigration consequence. But if I'm just clarifying and saying, no, I didn't mean a year, well, then it's not an aggravated felony at all. And I think that that's good reasoning. That was the state of affairs. And then Barr comes in and says, no, we're going to get rid of those tests and we're going to use this harsher test, which is, was there some kind of substantive or procedural defect in the underlying proceedings? If not, then they're convicted of the crime no matter what. You can't change it or adjust it. And I think that this decision does bring up a lot of due process concerns. So let's start here. Our criminal process is not perfect. Anybody who's ever been in a court or a judge understands that, yes, we're a country of high ideals and laws, and we're all trying to do the best we can. But our criminal justice system is a far cry from perfect, which is why I advocate for mercy in as much as possible. So what's interesting here is that a lot of immigrants will get, public defender, will get defense counsel, and they'll go and they'll go into a criminal hearing, and their attorney might advise them, hey, just take this plea deal. This is the best deal you can get. And the attorney might think that in their own head, and the immigrant just says, okay, sure. They'll believe what the criminal defense attorney tells them. And then some of the immigrants are savvy enough to say, hey, is this going to affect my immigration status? And some of the defense attorneys might say yes or no. They have a duty under a Supreme Court precedent to find out and know that answer beforehand. Although I guess not all do, because sometimes we'll actually have criminal defense attorneys call us up and say, hey, what are the immigration consequences of this? Or what should I try for? Sometimes you just honestly can't get a better plea deal if you're a criminal defense attorney. But if you're a savvy criminal defense attorney, you can go into the court, you can explain it to the prosecutor, you can explain it to the judge and say, hey, look, I know that 99% of the time, if somebody's charged with this, we do things in the following way in the following plea deal. But that's not going to work for this client because it will have this unintended consequence where they'll be deported back to, wherever, and where they might be subject to harm or those kinds of things, and say, hey, instead of sentencing them to a year, can I get 11 months and 29 days? And frequently when, and I don't do criminal, but we've worked with a lot of criminal defense attorneys. Frequently when we've talked with criminal defense attorneys and they try that strategy in court, that works. Most judges are like, sure, 11 months, 29 days. And prosecutors are like, fine. But that's, that doesn't happen in every case. Well, in this case from the Attorney General, he's saying you can't go back and have any clarification come through. Whatever it is whatever it is. But the problem here is that state laws don't contemplate immigration consequences. They shouldn't, right? But immigration judges should consider the impact of state laws, and they do. But what Bill Barr has done in this case is he's kind of foreclosed the opportunity for immigration judges to engage in any kind of analysis, individualized analysis, and give immigrants due process. And so in my view, it's not a great decision. He's couched it in language and in a factual scenario that looks like he was resolving a dispute. But the thing is both of those decisions that he resolved came out of the BIA. So, and frankly, the factual scenario was different. One of the orders was modified. One of the orders was clarified. That's a significant difference. And so, it's clearly just part of this campaign from the Trump administration to be more harsh. It's like the other opinion that didn't need to be written, but now it is written, that there's a rebuttable presumption that if you've got more than one DUI, well, then maybe you don't have the moral character that you should possess. And now we've got this other opinion that says, hey, no modifying, an underlying criminal conviction sentence, just because it might have unintended immigration consequences. That's too bad. But frankly, I think that, as immigrants become more savvy to it, as judges become more savvy to it, as prosecutors become more savvy to it, most prosecutors and judges and defense attorneys I know who become savvy to this issue say, hold on, if he takes this plea deal, then he's going to be deported? And they say, that's absurd. This is not what this is about. That's not what our criminal justice system is about. Now, I know that there are probably many people listening to this who are thinking, why do we care about criminal immigrants? They're criminals. But again, I'll just come back to this. If we don't protect these groups of people, then we're not preserving due process for everyone. It's a fight worth having. And then also, I just, again, believe in the power of redemption and coming back. There are some people who probably can and should be deported, right? I'm not going to deny that. But within our system of laws, we should make it possible for people to change and grow and learn. So that's it for Nation of Immigrants. If you like what you're hearing, please donate. Please help us support the podcast. Go to jacobtingen.com, subscribe on YouTube, follow us on Facebook and Twitter. I appreciate everybody who's been following, commenting, listening, watching. It's great to have all of you here. So thanks again, and we'll be back next time with hopefully more details about the U.S. immigration courts or whatever is happening in immigration in the news. Thanks.
Thank you for listening to Nation of Immigrants.
America is a nation of immigrants.
Subscribe to the podcast on iTunes. Watch the live stream on YouTube and Facebook, or visit jacobtingen.com to learn more.